Hi, this is Professor Chad McGuire, and welcome to this video session focusing on the private controls of pollution in our series on environmental law. This lecture is meant to follow the overview of pollution that you can obtain in the materials and also on the video lectures at the YouTube channel under environmental law as a playlist, or just in the video lectures or course lectures playlist. So here we're going to be focusing, we've already done an overview of pollution in general, and we've already focused on what we mean by pollution in relationship to the environment in US federal environmental law. And then to some degree, focusing on two major mediums of pollution that are controlled in the United States, and that's air pollution and water pollution. And we talked about some of we introduced the concept of private and public controls. And here we're going to focus in more detail on the private controls of pollution. By way of introduction, environmental laws, particularly command and control laws, are often effective mainly through enforcement actions. And when we say command and control laws, again, if you're seeing this without reference to the earlier introduction of pollution or the introductory materials to environmental law, command and control really means public laws. And public laws are those laws, statutory laws in the United States that are passed by Congress, the US Congress, or our elected representatives. So when we think about environmental laws, we often think about these public command and control laws, and they are often effective mainly through what we call enforcement actions, where you actually bring an action to enforce. And when we say enforcement, what we really mean by enforcement is judicial powers to review alleged violations of law and provide remedies. So enforcement actions means that in that public statute, and here we're talking about private, but just for reference purposes, in that public law, included in that statutory language is some language about how to enforce, who has standing, who has the authority to enforce violations, and where they go for enforcement. And often the case is, in many of these public laws, particularly environmental laws, it is the government that usually enforces the law. Private citizens sometimes also have a right to enforcement, but that right is usually delegated to the executive agency. And how that often works out is that the private individual notices something wrong. They think there's a violation of the Clean Water Act, for example, or the Clean Air Act. Their duty is to put on notice and inform the relevant agency. And if we're talking about federal for enforcement purposes, usually it's the Environmental Protection Agency. They might also inform their local state equivalent agency or local agent, local office of a state agency, which then would inform the federal agency like the Environmental Protection Agency. But the idea here is that you put government on notice and then you allow government to do an enforcement. In some environmental statutes, if government fails to engage in the enforcement action, then that private citizen has a right to enforcement. Regardless, in both cases, the question is, how do you enforce? And it is always through, in the United States, if we remember our separation of powers doctrine, then it's always through Article 3 of the US Constitution, the judicial branch. So we use our court systems in order to enforce environmental laws, whether that's the federal government looking to enforce or a private individual looking to enforce either a public law like the Clean Air Act or Clean Water Act, or a private law like nuisance or negligence that we're going to talk about now in this particular section. So when we say enforcement, we're really talking about those Article 3 judicial powers and what the courts can do in terms of providing remedies. And specifically here, we're focused really on, or at least we're looking at private control mechanisms of pollution, and then we'll follow this up with public control mechanisms of pollution. We're really looking at it through the context of remedies. So what remedies are available to you, and how are those remedies decided, and how are they enacted? And for the most part, the judicial system in the United States is the place in which we determine remedies. Statutes can identify specific remedies that are available, and under private remedies, common law traditions usually allow for court systems to have a lot more leeway in determining what those remedies are, but it always flows through the judicial system in determining really what potential remedies are available and how those remedies are decided and then enforced. So when we talk about remedies, what we're really talking about is the tools that are available to judges to enforce the law. Like I said, in many public statutes, Clean Water Act, Clean Air Act, that statutory law, it's the judges are provided with their what remedies are available. And sometimes the laws can be written very specifically, like if you find a violation, then this is the remedy. And in that case, the judges don't have a lot of discretion. They simply implement whatever the statute says. In other cases, it might be that if a violation occurs, then these potential remedies, these available these types of remedies are available under this law. They're intended to be available. Now, that can list not an exhaustive list of remedies, but a specific, set list of remedies, and the court can use its discretion within that list to enforce a violation if a violation is found. So the judges are given the ability to have some discretion. And in other cases, particularly when we talk about private law, like we are here, private mechanisms of pollution control, there may be a lot of discretion because there is no particular statute identifying. So the judges have a lot of room to determine what potential remedies are available. So the focus here is on, in this specific video, on private remedies. We're not looking at public command and control. We're looking more at the private remedies. So, but first, we can review the role of judicial review generally. We can, summarize the role of judicial review, or just how far a judge can go in devising a solution between public and private pollution control mechanisms. So before we look at private remedies, let's just take a moment to see that enforcement via remedies through the judicial branch, exactly what kind of, leeway and what sort of deference is given to judges in coming to a determination or being able to figure out the best way to determine what remedies might be available for a violation, for pollution under public and private law. So if we look at judicial review, generally speaking, we can say that let's start with the public law and look at statutory law. So if we look at statutory law, that congressionally made or, elected representative made law, and in the United States, it's our Congress, our two bodies, our Senate and House of Representatives that help to create law. Of course, the executive, the president signs these bills in order to officially legitimate whatever that bill is and turn it into an official policy. But when we have these laws, these official policies like the Clean Water Act and Clean Air Act on the books in the United States, they've gone through that kind of process, and we call that statutory law or public law. And when we're talking about that law in terms of judicial review, judicial review is generally constrained. As I said, it's constrained in the sense that Congress creates the statutory law, and under the separation of power doctrine, when Congress is explicit, when it says, if you find a violation, then this must occur and only this, this and only this. Sometimes the statutory language under the particular law is that specific. And when it is that specific, some say the judge's hands are tied. The idea is there's no discretion. So there's no room for interpretation. Once you've made a determination, a finding of a violation, then it's automatic. The penalty is defined, it's identified, it's defined specifically, and you have no room to change it, really. Very little to no room. So generally speaking, there's very little room for interpretation under statutory law in those circumstances. And even when there is some discretion, usually the statutory language limits the amount of discretion judges have in fashioning a remedy towards a particular wrong. So one of the ways we can think about this, of course, is we can remember our constitutional limits or our hierarchy of laws, which, again, we've talked about in the introductory materials to the environmental law lectures, and specifically referencing an entire video that you can find in the lecture videos playlist. It's in administrative law, but again, you can find an entire video lecture on hierarchy of laws if you haven't seen that and have reference to, and that can be very helpful. But we can remember our hierarchy of laws, which again tells us, just in quick summary, that generally speaking, there's a general hierarchy of laws in the United States, where if we think about it as a pyramid, at the very top of that hierarchy is the US Constitution. Below that are the laws, like the statutory laws that it created, and below that are the regulations that interpret the law. And what we're talking about here is the judicial role. of interpretation is when that statute is identified, then judges take the plain meaning of the statute. And when the plain meaning is unambiguous, then the interpretation is clear. You simply follow what the statute says. An alternative to this is to the statutory law, is what we're looking at here is really common law or private law. And under common law and private law, we can say that in terms of judicial review is much more open. And what we mean by open is that under common law, CL common law, it's judge-made law. By definition, common law is judge-determined law. There is no written law, usually. Some common law in some states, and sometimes at the federal level, a few common law traditions like negligence or nuisance, in some ways have been codified. They've actually been created. They've been given statutory life. And sometimes when they're codified, they're given specific remedies. But aside from that, generally speaking, common law is judge-made law, and there's a lot more discretion in interpreting common law principles under specific facts. So judges have a lot more room and a lot more discretion. When they find a violation of some common law doctrine, they can develop creative remedies. That includes, we talked about equitable remedies at the introduction to pollution. So equitable remedies are things like injunctions. That's one of the most important remedies. The idea that you stop whatever you're doing, you stop doing it. So if you think in the environmental context, hey, they're doing something that's harming the environment. Okay, I'm going to enjoin that activity. I'm going to, and there's preliminary injunctions before you even find a full finding of a violation of either common law or statutory law. That can be that, where there's the idea that there's a likelihood that the offending activity is truly happening, and that people asking for the injunction have a likelihood, a majority to strong likelihood of succeeding on the merits, of actually proving the case. And sometimes you can have a preliminary injunction where you stop the offending activity. So that's what equitable relief, and particularly injunctions, are meant to do. And then you can have other relief that follows as well. It's not just equitable relief, but you can have monetary damages and that sort of thing. But the point is, the court has a lot more discretion, a lot of tools at its disposal in order to determine whether a violation has occurred, and if it makes such a determination, what are the viable remedies. So judges can weigh, for example, in determining those remedies, interests of the parties, and apply principles in deciding remedies. And when we say principles, you can imagine, and we'll see here that we're talking about things like, if you're weighing interests of the parties, probably our dear cartoon economist, if we bring forward our cartoon economist versus cartoon ecologist sort of discussion or juxtaposition when we talk about environmental issues, particularly environmental law, what does the environment mean? What are the types of things that are, do we care about the economic cost of environmental protection to humans? So if environment means something that is human-centered, if our definition of environment is conditional on human well-being, then humans are at the center. And of course, human well-being doesn't just include, well-being in terms of, direct medical well-being, but also, the types of well-being that we would consider that included economic well-being. So do benefits versus costs come into play, that kind of thing, in terms of principles in deciding what's an appropriate remedy. So yes, you're harming the environment, but you're doing it because you're engaging in a highly valuable economic activity. And so to stop you from doing that highly valuable economic activity would have a significant impact on human well-being overall from an economic standpoint, which then of course includes, because when we think of economic standpoint, we think of resources. What I mean is direct human resources, human-derived resources. Think of wealth, for example, and then wealth provides the opportunity for redistribution of wealth for public services and goods and so on and so forth. And so is this something that has high economic value? And if so, we really then have to judge the environmental harms, the harms to the natural environment against that economic value. That's what the economists would say. The ecologist might say, well, no, if there is harm to the environment is important in and of itself. Therefore, we should protect the environment, maybe even, without considering the economic consequences. So just to remind us of that sort of, when a judge is weighing interests, what does it mean to weigh interests between the parties, right? And that's one way judges might go about weighing those interests. So let's look at two private remedies or private pollution control mechanisms. One of them, under common law tradition, is nuisance. The definition of a nuisance is, generally speaking, an unreasonable interference with the use and enjoyment of another's property. Usually nuisance is land-based. I'm just thinking historically in terms of what we're talking about here in terms of the environment. So we're thinking about, for example, a person use and enjoyment of their property, say their real property, their land, the thing that they might own from some other's activity that is having an effect. So under the common law principle, like I said, it applies to various forms of conduct across various mediums, air, water, and land. So, things moving through the air to something that you own, to land that you own, that sort of thing. The effect of water, if there's common access, public, there can be both private nuisances and public nuisances. So if the public has access and ownership over water, and somebody's, harming that water and therefore the uses for the public, then, there's the potential for a nuisance there. And certainly, like I said, land is the traditional way in which we sort of define that notion of nuisance from an operational standpoint and historically how nuisance has been used. Like I said, there's both public and private. So private is a singular, so private nuisance, for example, is a singular application of the law. It involves a limited act that has a particular result on either a single person, private nuisance, or a set of persons, public nuisance. So like I said, if you own your piece of land, you're a private citizen, an individual, somebody's doing something on the land next door, it's having, it's offending in some way, it's causing an unreasonable interference with the use and enjoyment of your property, your own private property, there's the potential for, a private nuisance, right? Or if you're in a larger setting where you could still be a landowner, but you could be amongst a community of landowners, for example. My beach example might be, or my use of water might be another example where the harm from an individual's activity, an entity's activity is having an interference with the use and enjoyment of a number of people's properties. You might have a generally speaking, a public nuisance because it's more than one person that's being affected. For our purposes, nuisance law helps us see the influence of private remedies as a mechanism for controlling pollution. So nuisance is, it's its own area of common law, of torts and that sort of thing. We can look at it, and equitable remedies, and we can study it, but separately, it can be very in-depth. For our purposes here, what we're using nuisance for is a way of thinking about environmental control using private mechanisms. Again, we can step back from put on our policy hats and say, from a larger perspective, are private remedies superior to public remedies? Are they a better way to protect the environment than things like those public laws, like the Clean Water Act and Clean Air Act, that are relatively speaking comprehensive? And there are those that say that private remedies or private controls like nuisance are effective, maybe better in terms of efficiency purposes. Problem is there's a lot of externalities that occur. We'll talk about that. We'll identify the sort of problems or limitations of private mechanisms. So there are two cases. They're in the materials for those that are taking the course, and others you can look up, Boomer and Spur as two examples of thinking about nuisance from an environmental policy and environmental law context as ways of thinking about how to think about private remedies of controlling environmental harm. Boomer v. Atlantic Cement is an interesting case. Effectively, what happened is that you have residential community, not a large community, but you have 8, 10, or 12 homes that are located in a particular area, in New York, back in the 1960s, approximately. And then you have Atlantic Cement comes into the area. So you have this pre-existing subdivision, let's call it, a small subdivision or group of homes in this local community. And then Atlantic Cement is a company, and it develops a cement company. It brings in and builds after this development exists, and that's important to know in terms of timing. So it knows that the residential development is there, but it comes in, it gets permitting, it builds a large cement factory, and it has significant economic benefits. It employs a lot of people relative to the community size. It generates a lot of revenue, so a lot of jobs, good paying jobs, and it pays a good amount of taxes in a relatively rural community. So relative to the community size, it has an outsized economic impact, strong economic benefit. One of the problems, though, is that as a result of the byproducts of generating cement, of actually it creates a lot of soot, a lot of exhaust, especially in the 1960s with the technology that was available at the time. And this is prior to the Clean Air Act, for example. And so the air of the residences that are located next to the cement factory starts being impacted. Basically, this, the byproducts of making cement caused a lot of particulates to move in the air. There were also noise and other things, but the particulates in particular would then come over to the residential communities and caused a lot of problems and caused them to suffer. And so they filed a private claim. Again, this is before the Clean Air Act, for example, but they filed a private claim and they claim nuisance to the sets of individuals, let's say 8 to 12 different housing units. And in claiming the nuisance, they say the company has created an unreasonable interference with the use and enjoyment of their properties. And the courts at this time, if you were able to show a nuisance, if you could, the prima facie case, was there an unreasonable, as unreasonable as defined in part by case law, use and enjoyment of, another's property, and the idea that, Atlantic Cement has no real strong defense to this other than, well, we did everything we were required to in terms of permitting. We're allowed to be here. We developed it properly. We permitted it properly. Everything's okay in terms of those things, how those things are considered. There are no public environmental laws or regulations that are preventing us from doing what we're doing. So everything seems to be okay. And we generate a lot of economic activity. That's basically defense. But if you could prove a nuisance, which they did, the landowners did, generally the standard remedy was an injunction, was that equitable relief and injunction. Sorry, Atlantic Cement, you have to stop your activity. But here, the New York courts, they decided something different. They said that, and we can get into the effect of the decisions, but they made a different decision in the Boomer case where they said, well, we really should consider the economic benefits of this activity. We should consider it, even though that a nuisance has been proven, what is the appropriate remedy here? Is it an injunction? Because if we have an injunction, hundreds of people are going to lose their job. Millions of dollars of tax revenue, of economic activity is going to be lost. And that's going to have a significant impact on the economic well-being of the community. So in this case, in Boomer at least, the concern is, yes, this is having an unreasonable influence on the human, because remember, this is talking about the use and enjoyment of their property. So this is definitely, if we're talking about our definition of environment, this includes a human-centric version of environment, right? So this is clean air for humans. What do we expect in terms of our general, air quality and that sort of thing? And what would be considered an unreasonable interference of whatever that expectation is? That's really what's going on here. So it is entirely human-centric. So that's what the court's grappling with in Boomer is, geez, how do I weigh the parties' interests here and the economic benefits of the activity, the cement manufacturing, right, is significant. There is harm, no doubt, but the harm's not to too many people. And the harm isn't, it's not killing them, that sort of thing. It's interfering with their use and enjoyment, but it's not maybe the worst. It's unreasonable, yes, but maybe it's not the worst kind of interference where it's threatening their lives, that kind of thing. Another case, 10 plus years later in a different part of the country in the Southwest, we have Spur Industries versus Del Webb development. In this case, Spur Industries is a cattle feedlot, one of these large scale cattle feedlots. And Del Webb is, the Southwest, you think of like Arizona, for example, it's really, and this is the 1970s, it's become a place, a retirement community. You have dry, warm weather, generally speaking, year round, and they're starting to really develop post-World War II and certainly in the 60s and 70s, retirement communities, these large scale communities for retired people to move from other areas of the country and retire. And Del Webb's one of those developments that are happening around this time. So it's a lot of people, a lot of buildings. Now, in this case, there's a couple of factual distinctions between Spur Industries and Del Webb. First of all, the cattle feedlot pre-existed the development, the Del Webb development. That's important. Remember, in Boomer v. Atlantic Cement came to the area and developed itself and built itself after those residences existed. In this case, in Spur, Spur has been there for decades. It's one of those old cattle ranches, listing cattle feedlot ranches that have been existing and pre-existing prior to the development of this community. So the developer, Del Webb, comes in, builds, knowing that there is this, downwind or upwind, I should say, this large cattle feedlot, and then builds a bunch of properties and then begins to sell them to unsuspecting, I wouldn't say unsuspecting, but I don't think that they're identifying that there's a huge cattle feedlot nearby. The reason why is because, a lot of cattle, they poop, and then that poop then, carries, flies and other things and smells. And, on given days with prevailing winds, that smell, all of that stuff, right? All of that stuff can move. Whatever it smells like to have a lot of cattle together can move into the air that is now what is the development. So you would think if you're selling these things, you definitely don't want the wind blowing from the cattle feedlot on those days, when you're showing the property. So the point is, the homeowners, what ends up happening is that they buy, they move in, and then they realize, oh, geez, there is this cattle feedlot that on given days, whew, this is terrible. This is horrible. So the homeowners get together, they band together just like the homeowners did in Boomer, just a lot more of them, and they file a lawsuit and they claim the same thing, nuisance. And they say, look, nuisance, Spur Industries, it's an offending activity. It's an unreasonable interference with the use and enjoyment of our properties. Please issue an injunction, which is the standard relief that is offered under nuisance law, especially common law. And the courts, in looking at it, said, okay, well, yeah, you're right. We believe there is an unreasonable interference with the use and enjoyment of your property. We find that the facts support that finding, that those, again, using case law, et cetera, and defining those terms, that, yep, you've proven your case, your prima facie case. And yes, an injunction is the appropriate remedy. However, there's a couple of intervening facts. Number one is that you came to the nuisance. That's always been one of these defenses to nuisance law, which is, look, I've been here. And the other people should have known and would have known, because I wasn't hiding myself from what I do. So those claiming a nuisance can't claim a nuisance, or at least they have a diminished expectation of unreasonable when they come to the place where they know that these smells and other things are probably going to happen, because here I am, I've been here. Atlantic Cement could never argue that, because the residential folks existed prior to Atlantic Cement. And Spur Industries, Spur existed prior to the development of the residential home community. So in this case, the court had to deal with a couple of things. It's like, well, you know what? Yeah, you're right, homeowners. You have suffered a harm, that's for sure. But your harm, you could have known about it. But more importantly, because you are such a large community, even if you individual homeowners didn't know about it, and that's entirely possible, the developer certainly should have known about it. So the developer's in a different position to develop this large tract of land. When they were buying the land, when they were subdividing it, they knew who was nearby when they were doing all of that sort of due diligence and early work. So Del Webb certainly knew coming to the nuisance is a defense. The other interesting fact about Spur Industries that's different from Boomer v. Atlantic Cement is that in Spur, the cattle feedlot certainly had economic value to it, but nothing in relationship to Atlantic Cement. It wasn't as high value, the economic activity, and it didn't create all of the economic benefits relative to the area, relative to its size, that Atlantic Cement was engaging in. So if the court was to start thinking about fashioning a remedy, again, it's going to put humans at the center. We're talking about nuisance, certainly humans at the center of their definition of environment. So the economist sort of world exists. That means very likely they're going to start thinking about benefits and costs. And so what's the effect, right? How do we fashion a remedy? And again, what we're talking about here in both of these cases is the courts have significant wiggle room to really think about how to fashion a remedy. So normally, if a nuisance is proven, then an injunction is provided. You get an injunction. We talked about that. That's the norm, right? However, in terms of questions that we can ask in this case, does it matter who was using the land first? Who was first in time, right? Does that matter? And like I said, in Boomer, the houses were there first. The residences were there. In Spur Industries, Spur, the cattle feedlot, was there first. Does that matter? And should it matter? Does it matter the economic benefits of the competing activities? Should courts be weighing, oh, well, Atlantic Cement a lot of jobs, a lot of economic activity, a lot of tax revenue, things that are important to a rural small community, any community in particular, but certainly a rural small community. Spur industries, well, I mean, Del Webb, so there's a lot of people, and that's a residential, retirement community. It's a large community. It has its own sort of economic nucleus, right? Spur industries as a cattle feedlot might not be nearly as significant from an economic standpoint. One of the questions we can ask is, does any of this matter, and should it matter? If you were the ecologist, you would probably be saying, no, none of this matters. We should be solely focused on a definition of the environment that is natural. Does either of these activities, the cattle feedlot or the cement manufacturing facility, do either of them have a significant impact on the environment? And if so, we should think about protecting that impact, limiting that impact. Now, again, there is no public environmental law that we can point to that would place the environment outside of, a sort of human-based definition. There's no sort of public definition of environment in some other law that we can use to say, hey, we need to just protect the natural environment outside of a human-centric definition. So this is really about, hey, air quality. It's really a question of air quality. Now that we have competing uses of this land, and this is another way to look at it. In the Boomer case, the land was being used for residential activity. Then came along, and we can assume air quality and all of those other things were pretty good. And so there was no scarcity of clean air for the dominant use in Boomer as the residences were enjoying, as those residential individuals, private citizens were enjoying their homes and the use of their homes, including the outside space. Then came along Atlantic Cement, and they changed. They fundamentally created scarcity. This is to use the economic ideology, right? So they made the air as a byproduct of creating cement. They made the air in the local residential community worse off. So clean air became scarcer. And once that scarcity existed, that's what economists always talk about, scarcity. This is where markets are supposed to work well, is when there's scarcity. They're most efficient when there's something that's in high demand. That markets are the more efficient way, and some would argue the most efficient way, of distributing scarce resources. Of course, the problem here is that, in this case, you are hard pressed to understand maybe how those private residential individuals would be able to bargain for, right, cleaner air. Maybe they would band together and try to pay Atlantic Cement, right? This would be sort of, we have to think of Ronald Coase theorem. We talked about this earlier, this idea that if you could just privatize public goods like air, right, air quality, or if you could just privatize them and create private ownership over it, and then you would have markets and market efficiencies would occur. So if those private homeowners, if they valued, this is the idea, is if they valued the air above their private homes more than what the value was being created, the economic value of the cement that was being created, then they would be able to pay for that cleaner air. They would be able to pay a sufficient price to stop to stop Atlantic Cement from producing the cement. And of course, we know that that's simply not the case, that they probably don't have the financial resources. And, we can take that same ideology. And again, now we have a new huge development in Del Webb, in the Spur Industries case. And that new use of land has created a lot of demand for clean air that never existed. So that air was fine as for that land that was undeveloped, as cattle feedlot byproduct air, whatever you want to call it. But once a bunch of people started using that land for residential purposes, all of a sudden there was scarcity created of clean air. And now those individuals at Del Webb demand that clean air, take precedence over the cattle feedlot air, the byproduct of the cattle feedlot air that Spur Industries was creating. And again, economic theory would say, well, that creates a scarcity, and therefore those individuals should be able to band together and pay for Spur to stop the offending activity. So we could keep that in mind. Those are deep economic principles, is if the highest value of the use of those lands in each of those cases is maintaining a quality of the air. And again, that quality of the air is being defined through human quality, right? What humans want to use that air for. The cement company wants to use that air for, at least part of that air, for a byproduct of its production process. Spur Industries wants to use that air, at least in part, as a byproduct of raising a bunch of cattle for the intended purpose of the cattle. And of course, the private residential people in both cases want to use that air for, at least clean enough to be able to go outside and enjoy without having to, have any adverse effects. So we can ask these questions, right? So injunction means stop the offending activity, regardless of the cost, benefits, etc. But the economic questions, really, some of it is that do the economic benefits of the competing activities, does that matter and should it matter? And then finally, are there remedies other than an injunction? Can the court do something other than just simply providing an injunction? And if so, how do you weigh the interests of the parties, right? How do you say to those residential users in the Boomer case, hey guys, you 8 to 12 homeowners, can you come up with enough money to entice Atlantic Cement to stop doing what they're doing? And of course, they would say, no, we can't. It's millions and millions and millions of dollars. 1960s, by the way, millions of dollars. We don't even come close to having that money, and we shouldn't, because we were here first in time, first in right, something like that. So that's ridiculous. This shouldn't be an economic argument. Whereas maybe in the Spur Industries case, the private homeowners would probably argue, or at least maybe some of the argument from the court in terms of weighing the interest, well, the cattle feedlot was here. You came here knowing it was here. You should have known. Maybe you didn't know, but you should and could have known that this would happen. And now maybe you should band together as part of your homeowners association fees and develop a pot of money that is able to pay Spur Industries in order to stop having so many cattle such that they make the air unpleasant for you. Again, in both cases here, what we're saying is that the private individuals do get out to determine what is the best use of that airshed. And we can obviously take this to its logical extreme and say that, look, in this world of private remedies alone, it's entirely possible that if you can gain enough economic benefits for some other purpose, that you can degrade the air to almost zero, right? The air quality can go all the way to really bad, really, really bad. That's what we mean when we talk about externalities, by the way, because generally things like air or water, we call them, again, public goods. And for those that are, what's a public good versus a private good versus, please go back to the introductory materials, the overview of environmental law. There are 3 video lectures discussing different parts of concepts of environmental law. Environment, what does it apply to? I think it's the second one, what does it apply to? You can see a nice sort of discussion of the different types of goods, public goods, private goods, that sort of thing. So, how do you stop externalities of these public goods? A person like Ronald Coase would say, well, turn them into private goods, make private, sell off the airshed, give people the rights to buy parts of the airshed, so on and so forth. And you can get into those arguments, but that's where those preliminary discussions and concepts are now starting to take life when we think about private remedies for pollution. So in terms of examining these decisions, in Boomer, the cement company gets to continue. So this is the holding of the court. This is the court fashioning a remedy that is not an injunction, or not just an injunction. In the Boomer case, what the court says is that, look, normally we would enjoin you from doing what you're doing, which is making cement. But because of the high economic value of what you're doing, we're going to allow you to continue doing what you're doing, but you have to pay for the nuisance or damage to the private property owners. So we're going to come up with some formula to determine the reduction in the use and enjoyment of the 8 to 12 landowners of their private property because of the decrease in air quality at the time of year and how many days of the year that you decrease the air quality sufficient that they can't use the outside at all hours of the day or at times, so on and so forth. So we're going to come up with some sort of mechanism, some sort of equation to determine what that value is. And we're going to place a dollar amount on it. And then you're going to pay them for the diminished use and enjoyment. So it's maybe not unreasonable, or we're going to take a stance and say, yes, this is a nuisance, but the nuisance isn't complete in a way. Because of the economic value of what you're doing balanced against the harm, we're going to say that the harm isn't complete. And therefore, you're going to pay for the diminished use and enjoyment. They can still use the property. It's not complete interference. They can still use it, but it is not as good as it used to be. So pay for it. A way to translate that is to say that it's okay to do environmental harm to the air, let's say, diminish air quality writ large, as long as you pay for it. And again, this harkens us directly into the economic argument benefit cost analysis. In Spur, the court said that the cattle feedlot, and this is weird because in the cattle feedlot came first, right? The cattle feedlot must close down. It must stop operations, but not the homeowners, because the court determined that the homeowners were innocent third-party purchasers. In other words, through the facts, the court said it is highly likely, this is a very large development, it expands a very large area, that when the average buyer is coming into this area, and particularly on the days where it might be, again, prevailing winds aren't making the, all of the worst case scenario of the cattle feedlot known and obvious to those potential purchasers. When they come in, they look at the property, they're unwise. And it's reasonable to say that they would be unwise, that they wouldn't be put on actual notice or even constructive notice of the offending activity, which is the cattle feedlot and some of the problems that can cause. And so as a result of that, they're innocent third-party purchasers, but the developer, Del Webb, certainly knew. So in that case, they said, you know what, Spur, you don't create huge economic activity, that matters. So we're going to enjoin you, but we're not just going to enjoin you in the end of the story. They came to the nuisance. The developer at least should have known and probably did know about what was happening, and the fact that, developing in this area with you existing would probably create a nuisance for the private landowners. And as a result, the development must pay damages for you closing down your operations. Another equation is developed, another determination on the future value, the present day dollar value of the future operations of Spur, of the cattle feedlot of Spur Industries. And therefore a monetary amount is determined, which then prevents it. We can also understand that there's a lot more people at stake in this case, meaning that not only is Spur not the economic engine that Atlantic Cement is in Boomer, but there's a heck of a lot more people that are claiming nuisance, the effects of the nuisance. There are a lot of homeowners. So again, here you see that sort of balancing happening here, where it's like, well, on balance, what's the thing that we need to do here? And of course, the outcome here is you have much better air quality overall through the stopping of the cattle feedlot and the offending activity, let's call it. So in this case, the majority of individuals win out, and the environment as a byproduct, the natural environment as a byproduct wins. But in each case, we can see how the environment is definitely a secondary consideration and maybe even a tertiary consideration under nuisance as a mechanism for controlling pollution. In terms of considerations, we can see clearly that we're employing a benefit cost analysis here. That's what's being employed. In Boomer, it's the value of the company higher than the pollution. And in Spur, it's the value of the harm. The pollution is higher than the value of the feedlot. However they're defining it, the end result, if we think of a scale, right, that's what's happening. It's a benefit cost analysis, straightforward. And when considering the interests of the parties, the court discretion does not mean environmental protection. There's lots of variance and subjective nature of assigning value to these variables, however they're defining these variables. The fact that the judges have so much discretion can be very beneficial when trying to understand the nuance of a particular case. But if we're thinking of environmental protection, that's certainly not necessarily a highly weighted variable in the analysis. So that's really important to consider. And of note, Boomer, pay to pollute, much like Coase theorem discussed earlier. I mentioned Ronald Coase, and again, the Coase theorem, the idea that, Boomer is the Atlantic Cement activity is such of high economic value, it outweighs, right? And even when they have to pay for the offending activity, still the net result is, a much better economic outcome, much more dollar value being, extracted as a total use of that land use area. Of course, the net benefit vis-a-vis air quality is diminished, right? So the question, it's like the Clean Water Act, right? What's that water body? And tell us how clean you think you want it based on human uses of that water body, right? And that's really, so we really should think about that from a policy standpoint is, well, who's making these decisions about how clean certain air quality, airshed needs to be, a water body needs to be. And then if you're just willing to pay enough, does that mean you can diminish the quality of something to zero, that you can totally pollute and totally diminish the environmental integrity of a particular area or region simply because you're using it for some other purpose? Is it okay as a policy in order to really incentivize timber production and agricultural production for Brazil as a national policy to say, get into that rainforest, the Amazon, get into the Amazon and start really taking down large swaths of it. It's okay, it's fine, because as long as we can say that the direct economic benefits of the use of the timber, the use of the wood products, and then once we've raised, that section of the rainforest, then turning it into, agricultural uses, at least for a few years, because, there's not a lot of the topsoil, have to, but regardless of those problems, the idea is, we can then use it for agricultural purposes and sort of human development and advancement. And that makes sense because that's a higher economic use. So we can see how this logic might run us into problems where you wind up with, our natural settings really suffering from this idea of direct, immediate economic gain for human beings. Outside of nuisance, another private law remedy we can talk about quickly is negligence. Negligence is another private law remedy, which allows an individual to sue another party for breaching some duty that causes damages. It's effectively these four important elements. You find there's a duty. These are the four elements you have to prove in order to show negligence. And again, negligence is a common law principle or concept that has generally equitable remedies and also other remedies, including damages and, in some states and maybe a number of places, negligence has been codified. It's been turned into a statutory, so you can look to the statute and specific definitions and nuances, but it is a common law tradition. And generally speaking, negligence, however it's defined statutorily or otherwise, contains these four elements. Duty is to act reasonably towards others, a reasonable person standard. Breach is a failure to act reasonably, however reasonably is defined, and it's usually, again, that third-party reasonable person standard. Causation is a legal nexus or connection between the act causing the harm and one's breach of their duty to act reasonably. And damages is a loss or harm directly related to the breach of duty. A lot of you might know negligence as fender bender, or automobile accidents, or slip and falls, or your local attorney, your torts attorney, right? A lot of the ways in which we interact on a personal level in the world of the laws, we understand these are things that happen a lot because there are a lot of humans that are going around to other areas and something bad happens to them. And usually they're claiming that bad thing happened as a result of somebody else's negligent act. They weren't paying attention, it wasn't intentional, right? The other car hit me, it hit my car because the person was distracted on their phone. They weren't intending to hit me. It wasn't an intentional act, right? But they were negligent. They failed. They had a duty to pay attention. They breached that duty because they weren't paying attention. Because they weren't paying attention is the reason that they hit my car. It's not because I slammed on my brakes. That's the causation, right? The nexus of connection. It's not because somebody else forced them to, speed over into my lane. Otherwise, they would have been hit, right? There's no other proximate or other reasonable cause to my damage. It's because of them, and it's because of them not paying attention alone. That's the reason I was injured. And then damages, right? I have damages. I have property damage to my automobile. I was injured. I was physically injured. I have medical bills, and I have long-term pain and suffering, that kind of thing. So those are the kinds of damages that occur. And we can think about negligence as a way of also a private remedy towards pollution, because you think about pollution, it's the same thing. And generally speaking, when we talk about sort of negligence vis-a-vis environmental pollution, we talk about it as toxic torts. That's usually the term that's used or historically has been used to define sort of the use of negligence as toxic tort actions. And harm is focused on the individual or group, not necessarily the environment. This is literally the same. It's another private remedy or private pollution control that is really focused on harm to humans, humans being at the center. I, human, have been harmed. Aaron Brockovich, you think of, the sort of Aaron Brockovich, this is in the early 2000s for sure, but in the 1990s, and she still does, this idea of, people have been suffering because there's been some negligence. Some company has discharged something, chromium hexavalent, some sort of toxic chemical, and it's, as a means of doing something else, and it's gotten into the water, and people have drank this water, and it's caused cancer. Another example is a civil action. If you've ever read the book, seen the movie, it's been a while, but Jan Schlickman there, another real life sort of person who was involved in these sort of toxic torts. The idea, again, I think it was what is that called there? The use of chemicals, basically. This is north of Boston, but the use of chemicals to what do they call it, with leather, to sort of cure leather and get it ready for all kinds of products that people want to use leather for, coats and handbags and things like that. So in the process of that, of curing leather, you have some toxic chemicals. They leach into the ground, they get into the groundwater. The groundwater is part of drinking water, and people are, made ill by it. So you think these notions of toxic torts. So negligence, that nobody's intending to do what they did, but they were highly negligent in what they were doing. They should have known, they should have paid more attention, they should have prevented the waste streams, and it's caused a lot of harm. So we can think of these, and the harm, again, is we're not thinking so worried about the water. That would be like a Clean Water Act, but if the Clean Water Act doesn't exist, we're thinking about the harm to the individuals in these cases, if that makes sense. We can juxtapose these on a large scale by thinking about, at least categorically, what are we talking about here? What are we getting at when we focus on what are private remedies for pollution control, and just private remedies in general in terms of trying to achieve environmental law or environmental policy objectives? Well, we can say, look, in terms of common law private remedies, whether we're talking about nuisance or negligence, they're on the sort of this left-hand side of the spectrum. And in that way, they are really focused, or the focus is on harm to the individual. So it's really about the individual. Whereas our statutory law or public remedies, which we will, again, we overviewed in our overview of pollution, and we will get into more details in the following lecture, a subsequent video lecture that's coming up. That you, by the time you're seeing this, should already be available, or closely will be available to you. But in terms of statutory law, public remedies, you have the Clean Air Act and Clean Water Act, examples that we've already used in our pollution overview. And the focus there is really on harm to the environment. What we can ask ourselves, again, to go back to our cartoon economist versus cartoon ecologist, is really, so common law remedies really embrace maybe some of that economist point of view, particularly when we're talking about as far as the remedies, when we're talking about how the harm is controlled and where the remedies are focused. The remedies are focused on looking at harm to the individual, to the human being, generally speaking. So, and in fashioning a remedy, as we saw in those two nuisance cases, Boomer and Spur, we're really talking about a sort of benefit cost analysis. Whereas on the other side, we haven't gotten into the details of some of the public remedies, but we did overview them. And we can say things like the Clean Air Act and Clean Water Act, they're much more programmatic. And they really are focused, even if our definition of environment is human-centered, which it often is for these public laws, they are. We worry about human health and human well-being as priorities. That's true. But we think about the medium and the cleanness of that medium to ensure overall, not specific individuals, but overall human health and well-being. And in so doing, we end up really focusing on that background environmental condition. Certainly, for example, the Clean Air Act, one of the impetuses for developing the National Federal Clean Air Act. You think about Los Angeles, we talked about the Los Angeles Basin, the smog in Los Angeles, just because of its natural geography and a number of conditions, that air, it was easy for all of that exhaust, leaded gasoline, and some other things. It was really easy for that, the exhaust and byproducts to really just be able to sit because of the natural conditions of that basin. It's like a bowl, Los Angeles. And so it's really easy to get that inversion and get that, all of those bad things, that low-level ozone and all of those nasty things to create all kinds of air pollution that is focused in that area. Certainly the human being's well-being and health was at the center of wanting to clean up that air, because humans were suffering. There were reduced days on average. The quality of life certainly was suffering. People were, not living as long. They were getting much more respiratory illnesses, the healthcare costs associated with that, all kinds of things. It's sort of a domino effect. Certainly humans were at the center of it. But in the way in which we looked at it, we said this is a public health issue. It's bad for all people of Los Angeles, and not just the current humans that live in Los Angeles, but future generations of humans that live in Los Angeles. So having a programmatic policy to help make the air better for those humans, what you end up doing is making the air better for everyone. You just make the air better. And because humans co-evolved and coexisted with background conditions that were much healthier with other species, when you make the air cleaner for humans in that way, you also make it more viable and better for other species. So when we say it's the ecologist, it's not a perfect ecologist argument, because often, again, humans are at the center of why we're doing something, but the net effect and the net impact can certainly be more natural environment orientated in these public statutory laws, certainly when compared to these common law private remedies. So I think that's really important as a takeaway. Final thoughts on these private law remedies for pollution. We can say pollution comes in many forms. We talked about two main forms as an overview of pollution. It's certainly more than that. It's more than just the air and the water and coming from specific sources. Private controls of pollution, they certainly offer a high degree of individuality to addressing pollution. And that in and of itself can often be attractive, and it can often be effective. We think of public control mechanisms, for example, because they're so broad, they're so large-scale policy orientated, they certainly are effective at ensuring overall protection, but they aren't very individually specific. Private control mechanisms they are individually specific. In some ways, we could argue, we could say, look, the mix of the two really makes a somewhat, maybe not an entirely comprehensive, but a more comprehensive policy approach to environmental pollution problems, because you have the public control mechanisms, large-scale approach, ensuring background conditions are taken care of. And then you have to follow that more specific applications in private law remedies. There could be instances where individuals, we just talked about them, we did the Jan Schlickman, the civil action, and the Aaron Brockovich scenarios. So there can be instances where individual acts lead to very discrete, specific individual harms. And these public mechanisms aren't sufficient at protecting against those individual harms. That's probably where those private control mechanisms offer additional aid and help, and are probably most valuable as a backup, as an enhancement of the public control mechanisms. One way to think about it. So in terms of private controls offering a high degree of individuality to addressing pollution, individuals determine the best, highest use of the resource. It's sort of our coast. Economically, scarcity can drive efficiencies in market transactions, and courts have a high degree of freedom in fashioning remedies. For example, you've done something wrong here. Pacific Gas and Electric, PG&E, I think that was in the Aaron Brockovich case, at least the one I'm referring to here. You have done something wrong here. Now, overall, you're a really important public utility for overall economic well-being of California, of the citizens of California. You provide important public benefits for generating electricity inputs, for heat, for the things that the Californians need in order to do what California needs to do. So you're an important business, you're an important thing. You have a real close association to a fundamental public good. But you did something wrong here, something specifically wrong. You allowed for these bad things to leach into the water system that affected individuals, certain group of individuals. And so we can see how in those cases, the kind of things that went on, the kind of actions that occurred in Boomer and Spur, having courts have a high degree of nuance and freedom in fashioning remedies is really important, because you have, first of all, a cause of action to help redress a specific thing that those larger public statutes probably don't address. That's important. So these people can go to court for something that maybe they couldn't under just trying to enforce the Clean Water Act or the Clean Air Act. It's one part of it. But the other part is that not only did they have a remedy, but the courts can fashion a remedy that is also acceptable. You can still continue to exist as a, as a company, because you're really important, but you really need to take care of you. First of all, you obviously need to clean up that mess, and you need to stop doing that. You're enjoined from doing that kind of conduct, allowing those bad things to get into the environment. You're not intending to do it, but you did, and it happened. So stop it, enjoin from doing that, and negligence proven. Now help these people out. Prevent this from occurring again for individuals like these people, and ensure that you can continue doing what you're doing. It's really important to have that kind of degree of freedom, maybe, in a society like ours. So you can see where that sort of benefit cost analysis has value for those individuals, certainly, and also for recognizing other benefits for a particular company. Overall, you can see its limitations if we're looking at it from a large-scale perspective about environmental protection. So private controls offer a high degree of individuality, I should say, to addressing pollution. But private remedies are limited, individual versus group, and they tend to focus on individual group harm rather than environmental conditions. So as a policy, when you're thinking about environmental protection, large-scale environmental protection, they are highly limited. They have their place, and they can certainly be supplemental, but they're limited. So the likelihood of externalities of public good values is quite high, right? If we allowed sort of Atlantic Cement, that kind of logic to run to its logical conclusion, right? Then anything that was doing a lot of good economic activity that had a lot of negative externalities, it would be allowed to continue as long as it paid for those externalities, maybe up to the point where those externalities now made it unmanageable to live, right, in those areas. So we have to be always wary of that from the larger policy standpoint. Another way of saying that is we could say it's okay to keep pumping carbon into the atmosphere until things get so bad and that the cumulative cost are so apparent and they far exceed whatever those direct economic benefits are, that we are then forced to try to change course. The problem there, of course, is like we talked about in terms of our systems analysis, once you've changed the Earth system to such a point, it doesn't matter maybe by stopping using carbon, because now that you just have so much carbon in the atmosphere for human lifetimes, for generations, it's unlikely that you're able to sort of mitigate, right? There's very little humans can do at that point to stop all of that new additional cost that we're incurring because of the environmental harm that's been added up. You just can't just snap your fingers and change direction and say, okay, that environmental harm doesn't exist anymore because we've stopped these activities now after the environmental harm has been fully realized. We might have a new equilibrium state. That's always dangerous. So maybe public controls help develop a holistic approach. In other words, public controls are that large scale umbrella holistic approach. So we can think about it that way, And so that's it. Now we have a sense of private control mechanisms over pollution and larger scale, where they fit in terms of our thoughts about how to protect environmental values. How we define those environmental values, human, natural, something in between. And the fact that they are, in many ways, they lack a comprehensive approach to protecting environmental assets. Okay, next time, our next video, we're gonna talk about some of the public control mechanisms and how they might offer that more comprehensive approach. Thank you for your time.